Hello and welcome to Manika IAS. So far we have discussed about Article 14, 15, 16, that is fundamental right to equality. Now in today's video we'll be discussing about Article 17 and 18, which also comes under the fundamental right to equality. First of all, let's start with Article 17. Article 17 essentially deals with abolition of untouchability. So if you we all know that untouchability is a sort of discrimination on the basis of caste or maybe occupation, right? So we have read about this in our history classes, that what kind of untouchability was prevailing before independence. So this particular article says that untouchability is abolished. It is abolished, it is finished, and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with the law. So, here they're talking about two things. One thing, it is saying that untouchability is abolished. That means, as we discussed, the untouchability is abolished, it is directly enforced. Ki once it is said it is abolished, it is finished. It doesn't require any law for it to be finished, right? Then the practice in any form is also forbidden. You cannot practice untouchability whatsoever may be. Second, it is empowering the parliament to frame laws to make it a punishable offense and to decide what are the punishment of practicing untouchability. Although the first statement is saying ki it is abolished, but what if somebody still goes and practice? Where are the remedies lying? So it allows the parliament to make it enforceable by declaring punishment under a law, right? So what does that mean? Ki although the abolition of untouchability is there, it is abolished, it is being established by the constitution, but to make it punishable, and what sort of punishment, the law is required for that purpose, right? Now again in article 35, legislation to give effect to provisions of this part. This is an associated articles because it is this article which is empowering the parliament. It says that there should be a law enforced in accordance with the law, but it is this particular article which is giving the power to the parliament to frame laws. Parliament shall have and the legislature of state shall not have. That means this law which it is saying to be made for make it punishable has to be come from parliament, and state legislature cannot frame a law on this. ठीक है? With respect to along with this particular article under 16 clause 3 that we have discussed earlier, 16 3 32 clause 3, 33 article 34, this will be dealing later. But for this, for prescribing punishment for those acts which are declared to be offences under this part, because it is declaring this untouchability, practice of untouchability, as an act which is punishable, and for those it is the parliament who has to make laws or acts to make this happen, okay? And it is the state legislature which cannot do anything about this. It has to come for parliament in order to have uniformity, right? Now let's go to the acts which are being made. So Parliament, in order to make untouchability and punishable offence, has brought two acts. One is Untouchability Offences Act 1955, right? Originally, this act was non-cognizable and bailable. Now, what does that mean? So, if you will say see IPC, there are few acts which are considered as cognizable, which are not considered as non-cognizable. So, the very extreme cases like murder, rape, these are cognizable crimes, whereas others are non-cognizable. And then it was also made bailable. So, this appeared as if it is a very loose act. It is not stringent enough to uh, curtail the practice of untouchability, right? So then it was again amended in 1976, and it's also renamed as Civil Rights Protection Act 1955, and it was made cognizable and non-bailable. Now, when it was bailable, courts plus police can grant the bail. But when an offense is non bailable, then police cannot grant bail. It has to come from courts. So only when the case will go to the court, then the court will grant bail. Police on its own cannot grant bail to the known bailable offences, right? Second act, which was given by SC Prevention of Atrocities Act 1989. Later, it was amended in 2015. And if you'll take up the newspaper of 17 and 18, you will find that this particular act was making into the headlines because it added certain new provisions, and it was also debated from the other group that it's going to make it more stringent, and falsify of cases will also be there. So, however, the it added new provision which are illegal occupation of land. It if if any non-ST SC members is illegally occupying their land, then this will come into play. Then, if forcefully they are compelled to do menial acts, okay, if they are also compelled to vote, you know, when if you see that there is a practice of buying the votes, or threaten people to vote in particular favor of a particular party, then also this act will come into place. And second, there has to be special courts at the district level to deal exclusively with these cases. Special courts has to set up, although we have not seen much special courts so far, but this was the provision. It also said that in case any civil servant is not doing justice to SC and ST, this will also come into the place. If non SC and ST civil servant is also not doing justice to SC and ST, then also this will come into place. Then Article 18. Article 18, it says abolition of titles. So what are titles? Titles, if you have read the history, you know that we used to call, Raja, Maharajas. People were called as by Raja, Maharaja, Maharaja Dhiraj. These are the titles. Now, this created an hierarchy between the normal civilians and the people who were called as Raja, Maharaja. So, in order to promote social equality, this article was brought into place, and it says all the titles are not to be used, they are abolished. No title not being a military or academic distinction shall be conferred by the state. That means state cannot confer any title other than a military or academic distinction. Say you have Padma awards, Paramveer Chakra awards, है ना? So those sort of awards are allowed, but you cannot use them as titles. So awards are allowed but can't be used as a prefix. You cannot use like Padma Award and say Sachin Tendulkar after it. You cannot use that. You uh, Although these are allowed, but they cannot be used as a prefix, because in order to have a social equality. Then in Supreme Court in Balaji Raghavan versus Union of India 1996 says that Padma Award equivalent to the academic distinction, and it is not a title. So it upheld the giving away of these Padma awards because it was challenged. So it says that since it is an academic distinction, it doesn't come under titles. So the other provisions are, now, no citizen of India shall accept any title from a foreign state. It forbids all the citizens of India to accept any title if it is given by the foreign state. Then, no person who is not a citizen of India shall, while he holds any office of profit trust under the state, except without the consent of president any title from the foreign state. That means a person जो इंडिया का citizen नहीं है, and if is holding any office of profit means any profit, any office which is any position in the government or anything which is giving you a sense of financial returns, then you cannot accept any sort of titles from any foreign state without the assent of president. But if you take the assent of president, if president says okay, yes, you can have the title, you can go and take the title, then they can accept. Other than that, they are forbidden to accept the any sort of titles. No person holding any office of profit or trust under the state shall, without the consent of president, accept any present emoluments, office of any kind or under any foreign state. So if you see that it says that ki no person who is holding any office of profit. So this was the people who were outside, not the citizen, not citizens, right? And this is dealing with the citizens who are holding the office of profit or trust. They shall not accept present emoluments and office of any kind from the foreign state without the consent of president. So if we say today our prime minister goes and get any gift, it has to come with the assent of the president. It cannot come without the assent of the president. So president has to give their consent, and this is what article 18 and 17 are all about. In the next video we'll start with right to freedom and article 19. Read the article of related to right to equality. If you have any doubt, any question, you may please ask. And till then, have a good day. Thank you.